Hello, my name's David Runciman, and this is Past, Present, Future, the History of Ideas podcast. Today, I am talking to the forensic anthropologist Sue Black about what happens when forensics and forensic expertise is put on trial in a courtroom. This is not strictly about a bad idea. Forensics is not a bad idea. There can be good forensics and bad forensics, just as there can be good science and bad science. But forensics is often badly treated and badly handled in a courtroom. We're going to be talking about some specific cases, including the case of Lucy Letby. This episode also connects to another series that we have done quite recently, Politics on Trial, about what actually happens in courtrooms and some of the things that can go wrong. Above all, though, this is just a really interesting subject. Sue, you write about the experience of being an expert witness in the British criminal justice systems. In Scotland, England and Wales, somewhat different experiences, but within that system. And to be honest, it sounds completely terrifying. It's uncertain, it's precarious, it's brutal. You have lawyers who, in order to, as they see it, serve the interests of their clients, want to trash your reputation, not just on that day, but once and for all. You have juries that may completely ignore the evidence that you presented and reach baffling verdicts. And yet I think I'm right in saying you retain faith in this way of doing justice. So that's where I want to start. Do you retain faith in this way of doing justice? And if so, how do you reconcile the experience and your faith in the system?
I think, first of all, it's an acknowledgement that it's not perfect. And it is a very imperfect system. But I'm not convinced that there is another legal system that is any better. So whilst we have an adversarial system, we have two sides in a courtroom. One side in the courtroom brings the charges and the case that needs to be heard. And they need to prove beyond reasonable doubt that what they say happened did happen and who did it did it. And the other side of the courtroom is simply there to introduce sufficient doubt, because if there is doubt, then you can't convict. So they're not looking for innocence. They're just looking to implant doubt. And the defense team are there working for their client. The client on the other side, of course, is not the victim. The client on the other side is the Crown, because a crime has been committed. And you are a pawn in this game. And it's an ancient game, and it's a game of rules that we try to understand, but we're not lawyers, and so we can't understand the details of them. But we have to be absolutely sure of our role within the game. But that doesn't mean, though, that somebody can't play a really good strategy and you find yourself in a part of the game where you don't want to be. So it's absolutely a system that is just stacked with things that can go wrong. And they do. And we know they go wrong because we have miscarriages of justice, where we've gone back and we've reevaluated a case. Maybe it's because something was done during that case, the person didn't have a fair trial. Maybe it was because science has moved on. Maybe it's because that particular expert has subsequently been shown to be unreliable. But we will, through an appeal system, go back and look at a case again. So it's not as if once you have that conviction, there is nowhere else for you to go. Appeals are there, but they're not easy to get. And so it's really behooves us to be able, when we go into the courtroom the first time, to get it as right as we can. And we don't know what's right or wrong because we're not there as advocates. We are there simply to present the evidence and, in an opinion that is our own, convey it to members of the public. Now, those members of the public probably haven't read any science since they were in school. And that might have been when they were 16 and they're now 65. And science may just be something that doesn't interest them at all. So not only do we have to know our limits, we have to be able to convey sometimes what is really quite challenging science into a language that is easy to understand and interpret. So with so many different parts in the play, you can see where it can go wrong, and it does go wrong. but we just do our best. And if you don't believe in the justice, what else is there? Because it's the most important thing, is that we trust our courtrooms to get it right more often than they get it wrong. And I'm sure that they do get it right more often than they get it wrong. But when you get it wrong, you have to analyze it.
As you say there, you think it's the least worst system. It makes mistakes, but you wouldn't choose to do this under another system. But there are different systems, and there are non-adversarial systems, there are non-jury based systems. As an expert witness, are there not moments where you wish you were in a court in which a magistrate style judge was presiding, in which your expertise was not subject to the ping pong match that takes place over your reputation between the rival advocates? And as you say, your job is not to be on one side. An expert witness is not there to be on one side, but inevitably, one or other of the sets of advocates will treat you as being on the other side because they will have decided that your evidence benefits not their client, but the other side. It might be the Crown or it might be the defense. Do you never have moments, as I was reading your account of it, I wondered whether you have had moments where you wished you were in a different system, accepting that you think maybe in the long run, other systems, of course, have their own flaws too?
I think every single time I'm in the courtroom, I wish I was somewhere else. And certainly, I've never given evidence in an inquisitorial court, which is the other system that you're talking about, where the judge or the magistrate makes the decision based on the evidence in front of them. And the experts are experts assigned to the court. I've never given evidence in that situation, but colleagues of mine who have say that it has its own problems. And that's why I say I don't think there's one system that works absolutely perfectly every time. There are pros and cons on both sides. There is a tendency, they suggested, in the inquisitorial system that once you've got an expert witness in, they become the pet expert witness for that court, and they become the one that works with that judge because they know how that judge works. And that doesn't always give you the sand that you need in the oyster to create the pearl. So sometimes I think you need the friction. Heaven knows I would like less of it, please. But I think there are times when that friction actually does whittle out where you have an expert who perhaps shouldn't be giving expert testimony, or they are using methodologies that aren't up to speed or that they don't fully understand. So I think we have to, I always say to my colleagues, pull those big girl pants right up to your chin because, we've just got to get on with it. It's the best that we can do.
So I want to go on and talk to you about sort of pseudoscientific expertise and some of the ways in which it's important to guard against that. But as you've suggested there, part of the challenge is to present the evidence to a jury who may have no scientific understanding, no interest in science. It's striking in your descriptions of various cases, both your own and historical cases, how much time is spent not really interrogating the evidence presented by the expert, but interrogating the reputation of the expert, almost as the quickest way to connect with the jury, so that you can say to the jury, it almost doesn't matter what this person is saying and whether or not you understand it. What you can understand is I have shown you this is not a reliable person because they've inflated their credentials, or this thing happened in the past, or they've stumbled in the courtroom. They've failed to answer a question which has got nothing to do with the case, but suggest that. And again, that feels like the precariousness of your position of an expert witness. You're defending your reputation against people who have a primary interest in trashing it.
So I have a very dear friend in Scotland who is one of Scotland's most notorious defence barristers. And he's not my friend in the courtroom. He really isn't. But outside the courtroom, he is my friend. And every time I've been in front of him in the court, the first thing he says is, "And your age?" And I think, "I've no idea how old I am." And I say to him, "Why do you keep asking me that?" He said, "Because you never learn. And I always get you on the back foot just with that question." And, so it comes down to just simple things like that, that you can, I learned eventually to figure out how old I was, but you can prepare yourself for it. But it is a theatre. It is a gladiatorial theatre. And, blood will be shed. And you just don't want it to be yours, not this time round. And nothing prepares you for that because You've almost got to go through it to find out what it's like. And for some experts, it is just too much. And they will go into court and they will have a really bad experience and they'll say, I'm never doing that again. And my fear then for the courts is that what you're doing is you're preventing these future experts who could be really helpful in future cases. You're bloodying them so early on that actually you're getting them out of the profession. So what you get left with are the wizened old rhinoceros that has skin as thick as the proverbial rhino, who sees it out, but we're not getting the young people coming in because they're saying, why would I risk my reputation for that? Why would I put myself on a stand every single time for somebody to try to knock me down? And that's the bit that I think is probably most challenging. If we could get past the, is this the correct PhD title that you've got? How many papers have you written on this subject? If we can get past that into the area that says, let's talk about the evidence. And please, please, absolutely challenge me on my opinion on the evidence. But please don't challenge me on the degrees that I've got because I'm so old. I got them when Methuselah was a boy, and it really isn't relevant anymore. But that's the way the system works, and you just have to go with it. And when you're a middle aged, red headed Celtic woman, what you desperately want to do is to shout and say, for goodness sake, can we just talk about something that matters? And you can't do that. So the whole time that you're in that box, you have to remain calm, you have to remain respectful, you have to remain helpful, but inside you're shouting really loudly.
It also, if it frightens off the people, the younger people, the people whose first experience is too gruesome of this, it also leaves the people who enjoy it too much. So you write about some notorious miscarriages of justice where it's not that the experts weren't experts, but they think they're really good at the game too. They think they know how to connect with a jury. They think they know how to communicate in everyday language. And they go beyond their brief in a way. And you do get disastrous results. I have to say, I think all the cases you cite like that, they're all men. I think I'm right in saying.
I couldn't possibly comment.
Well, I can, and I think it's fair to say they're all sort of middle-aged, complacent men. They might all be senior as well in their own professions. But there is that side to it too, which is there are some people who like the game too much, I think.
Yes, you believe the rhetoric. The classic one was Bernard Spilsbury, who was the forensic pathologist at the turn of the last century. And he was such a media star. He was one of our first celebrities in the forensic world. And he would turn up in his frock coat and his top hat and his red carnation and his spats, and he looked the part. And the media just loved him. And they hyped him up to such extent they would say, Bernard Spilsbury is in the box, the case will be over soon. And he's started to believe his own rhetoric about himself. And once he got to that stage, he then became dangerous. And it was the judges who started to feel uncomfortable that he was going beyond his own area of expertise into areas where he had little knowledge, but he felt he knew everything. And I think, when I came into this world of forensic science, we had quite a few of those early day forensic pathologists who believed, and they were men, who believed that they knew everything. And you coming in as the girl from a sort of niche expertise, there really wasn't a lot of room for you. And you had to win your spurs and you had to win your credibility and your place within the team. And by and large, those characters have gone now, but they were of a time, and it takes time for them to work through a system.
Another turn of the century case that you write about, which is quite a good example of this, is the Dreyfus affair and the ways in which experts can be drawn from their field of expertise into a field where they are not experts at all. Do you just want to tell that example? Because I think it's a really good example of this.
Dreyfus was just such a horrendous case at all sorts of levels. And it was all to do with spying, and it was to do with whether information was being transferred to the Germans. And a note was found, and it had been ripped into, I think, 6 pieces. So it wasn't difficult to piece it together. But the whole question was who had written the piece of paper. And the study of handwriting, there's not a lot of science in there. It's about pattern matching. And I don't know about you, but I can look at my handwriting and it looks different from one day to
Yeah, or your
another,
signature,
depending upon,
presumably.
or my signature, depending what I'm writing with, what I'm writing on, and what mood I'm in. But in terms of authenticating documents, we will look at handwriting and signatures. And they needed somebody to blame. And Dreyfus was somebody who was in a perfect position to be blamed because he was of Jewish extraction and he would have made a very convenient literal head on the spike. And so experts came forward and they said, yes, this was his signature. And he was found guilty of spying and he was placed in prison. But then there was a question raised, was it him? And they examined it again. And so what the courts felt they had to do was to find the biggest name that they could and bring that big name scientist in, because that would persuade the jury that they'd got it right the first time. And Dreyfus was sentenced to so many years in prison for something that he really didn't do, on the back of a really strong rhetoric from the prosecution, really dodgy evidence, no scientific basis behind it, and a perversion that was determined to find him guilty because the alternative was just too awful to consider, that he might actually have been innocent. And it was a huge, huge miscarriage of justice as a result. But it was using something that people of the time believed in and wanted to believe in and believed there was science behind it, but there was no science. It was just pattern matching, and pattern matching is a huge problem in terms of probability, likelihood, and certainty.
So many of these cases turn on probability, likelihood, uncertainty, and understanding of statistics. So again, in the Dreyfus case, it is inconceivable the expert will say that these two pieces of handwriting don't match, even though in some obvious ways they didn't match. And then the absurd explanation that was given, which was, well, what really proves it is that he was disguising his handwriting so that that confirms it, because the fact it doesn't match is evidence and the fact we say it does match is evidence. So that was bad, but even good science turns as evidence in criminal justice cases on probability, and probability is complicated. On this podcast, we did a program with David Spiegelhalter, the statistician, and he was talking about Bayesian statistics. And he was explaining to a general audience, which absolutely includes me, how Bayesian analysis works, why it's so important across so many fields, from artificial intelligence through to criminal justice. That was a part of what we were talking about. And he said one of his frustrations was that in the British criminal justice system, statisticians are not allowed to be called as experts simply qua statisticians in order to help the jury understand probability. He, David Spiegelhalter, would not be called after an expert witness to say, you've been told it's a 1 in a billion chance. Now I'm going to tell you how to interpret that. The system assumes that the jury will hear evidence presented in probabilistic terms, and then the jury will reach its own judgment. Now, as someone who finds probability puzzling and challenging, it's really hard for a jury to do that. And yet the system seems to say we will allow experts to talk to you as though they were experts in statistics. And you say in the book, you are a forensic anthropologist, you are not a statistician, but you have to use that kind of evidence. But they won't allow statisticians as experts. It does seem like a real anomaly in the system.
It really does. But I also know that the minute you start to talk about statistics, probability, you can see the jury, they just glaze over and they switch off. And I think it's a really difficult, because it's such a difficult subject, it is difficult to get across. And the prospect of bringing in somebody who was just a statistician would probably be really uncomfortable for the judge, really uncomfortable for the lawyers, and three times as uncomfortable probably for the jury. So there's probably a feeling of it may cause more rather than less confusion in the courtroom. But where we really, really need the statisticians, if we're not going to let them into the courtroom, we really need them on our forensic teams as we're working, so that they can advise us. What does that really mean? What is the scientific background to this? How sound is our data? What can we interpret from us? We almost need them to be advising us. If we're going to have to be the ones fronting it, we need their advice. But what they can also do, the statistician, which is so helpful, is that they can see the cases from the outside and they can analyze them from the outside and they can say, whoa, hold on a minute, this isn't right. And that's why you start to see the Royal Statistical Society having a forensic and a legal committee, because they will look at cases that are happening in the judicial system and they can see where it's going wrong. And the more that they can remind us of how important their expertise is, the better the chance we'll ever have of getting them into the courtroom. I'm not sure that we will, but we certainly need their advice.
If it's true that juries glaze over, and I completely get it, David Spiegelhalter is a brilliant communicator, but Bayesian analysis is hard to understand. And I can imagine even he in a courtroom might find that the jury's attention wandered as he explained the theory. So the tendency is to put it in as simple terms as possible and in terms that people can understand. And this has also been true in some notorious miscarriages of justice cases that you write about, for instance, the Sally Clark case. So that case, the Sally Clark case, was about two infants who died of cot death to a single mother and the likelihood of this happening in one family. And the jury was told it was impossibly unlikely because here's the likelihood of a baby dying of cot death. Here's the likelihood of a second baby dying of cot death. Basic probability theory tells us we multiply the two together and we get a very, very high number. And suddenly the jury are told it's infinitesimally unlikely. And that is language that people can understand, but it's really bad statistics. It's wrong because it doesn't take account of all of the other ways of interpreting this evidence.
Because what they were saying was actually if you have one child die, you actually have a greater likelihood of a second child dying.
They're not unrelated events.
Absolutely, absolutely. And so, that it's terrifying that an expert in a particular field, and we're talking about Roy Meadow, he was an expert in his field, but what he did was he strayed beyond the boundaries of what he understood, and he multiplied factors together that he shouldn't have multiplied. And it became his law, and it was named after him, and he started to believe his rhetoric. And he became more and more confident in his views. And that's when an expert witness becomes dangerous, when they feel they have a confidence in an area that is not their level of expertise. I love nothing more than standing in the box and saying, that is not my area of expertise. And you can get away with it for a little while, but you can't get away with it forever. But I did have a very difficult case, and a photograph of the child was shown to me to say, but look, isn't this a happy child? And I have to say, I'm not here to give evidence on whether this is a happy child. But, you can look at a photograph. Isn't this a happy child? I am not here to give you evidence on whether this is a happy child. And that's the only time that a judge has ever stepped in and said, your question's been asked and answered. Move on. And you have to really know where your boundary is and be prepared to fight to hold it. Because the minute you cross it, then you're in really dangerous territory, not just for yourself, but actually for, as you've heard with Roy Meadow, what then the jury hears and where the jury goes beyond then. So justice becomes actually at risk when an expert oversteps their own mark.
Can I ask you about a case that you do write about, prefacing this by saying you have no involvement in this case, I have no involvement in this case. We are discussing it as people who have observed it from the outside. It is a case that still and will continue to provoke strong feelings. I've witnessed passionate arguments between people who have no involvement in this case. It's the Lucy Letby case. Lots of questions, concerns have been raised about that trial that convicted her of multiple charges of murdering babies under her care as a nurse. There are lots of, I think, questions about how that trial took place. One of them is that the defense strategy seems to have been baffling because there were expert witnesses on one side that were not challenged. Another, I think, is the way that statistical evidence was presented in that case. So without wanting to draw you into territory that will get both of us subject to online censure from all the people who feel passionately about this. What do you think at this point we can say about that case and the ways in which expert testimony was used?
As you say, I was not involved in the case, so I have no inside knowledge. Like every member of the public, I've listened to it on the radio, on the television, I've read it in magazines. A brilliant book by a couple of investigative journalists who desperately wanted to come down on one side of the fence or the other and found that they couldn't. And I thought it was really enlightening because it was at a time when I was writing my book about being an expert witness. And I could sort of step back and look at it from the perspective of the witnesses and where there were problems with the witnesses. So, for example, the prosecution witness in particular was somebody who came forward and offered their services to the police. Now, that's something that we don't do. You wait until you're asked. You don't offer your services because there's a bias involved in there. And you know that if the defense are going to do their job, they're going to come at you for that. So even from that perspective, that was odd. The evidence was about a volume of evidence, but not about as a quantity, not a quality. So there was no forensic evidence that I could see. The babies had all gone for postmortems, and the postmortems hadn't raised any red flags. Everything was being found retrospectively. And for me, that's something else that should have come out, I would have thought, in cross examination. But then, as an expert witness, you don't know what the legal strategy is on the other side. And I don't think any of us still know what the legal strategy was from the defense. Why you would put the jury in a position to hear one side of an argument but not hear the other, I don't understand. I would have expected a judge to step in and say, this is an uneven representation because the jury needs to make up their mind. If they only hear this, that's what they'll make their mind up on. You need to introduce reasonable doubt. But maybe there is no reasonable doubt, but it transpires that there is. So it's the strangest of cases. And I think you're absolutely right. It's not going to end anytime soon. My fear now is if it goes back to a retrial, how you can have an unbiased trial, given that there has been so much hype and so much media about it. The statistics are really important as well, because in the book I was talking about other cases where similar situations of nurses were being accused, and the similarities are really quite frightening between the cases. And that whole piece of, I'm going to put it in inverted commas, evidence, which was the list of who was on duty at times when the babies unfortunately died, only looked at nurses, didn't look at porters, it didn't look at doctors, it didn't look at auxiliaries. It's an incomplete list, and that's what the statisticians are picking up on. Something really quite perplexing. And I just wish we could know what the legal strategy was for the defense at the time, because I've never seen a case like that in my time.
And it did turn, I don't want to compare it here to Dreyfus, but it did turn effectively on pattern recognition that the jury could understand. Look, the only person, given the evidence that was presented, who was on duty when these babies died is the person in the dock. There were handwritten notes that that person had written under pressure that seemed to implicate themselves. But there are so many other ways of presenting that evidence, and it's so baffling that the defense didn't try them, including in simple probabilistic terms, but terms I think a jury could understand. You are being shown one person was on duty when all of these events happened, so it seems incredibly unlikely that there's not a connection. But all the evidence about the woman who was accused, it was incredibly unlikely that such a person would be a mass murderer. And in Bayesian terms, it depends what your priors are here. And there was no opportunity given to the jury to start from another place. They might have come to the same conclusion, but they weren't given the chance to start from another place, which I feel like the adversarial system, that has to be the basic function that it serves, to go back to where we started. It at least gives the jury competing stories to choose between.
Yes. And then they have a choice. They then can make their choice as to whether they think the evidence is lying to one side of the fence or the other. But if they only ever see what's on one side of the fence, they can't be expected to understand what's on the other side. I just find it utterly baffling. And on something so important, because there are families out there just in, such incredible pain at the loss of their babies, having to go through the court case and now having to hear all of the evidence that's suggesting this may have been flawed. What a dreadful place for them to be in. There is no winning in this case. I think that's the big problem. Who wins? Everybody has lost. The courtroom has lost some confidence. The public has lost a bit of confidence in the courtroom as a result of it. It's not going to bring the babies back to the parents who've lost them. That's the real pain.
You said earlier it's crucial for a system like this one to be able to correct its mistakes. It's slow. Inevitably, the system is very resistant to doing it. There's clearly a fear, and a completely understandable fear, that you lower the floodgates a tiny bit and you will be overwhelmed. Almost everyone in prison says they are innocent of the crime for which they were convicted. You don't want to allow the system to be swamped. But at the same time, in the Lucy Letby case, I'm sure I'm not alone in feeling this, you feel, how long are we going to go on before there is an opportunity to have a look at this again? With all the caveats that you've mentioned, it's going to be very hard to have a fair trial again. But the system seems very resistant to this. Do you think it's too resistant? Do you think that the floodgate, if I've got the imagery right, is set too high?
I think that's a really hard question. And the reason I think it is so difficult is that the law is not necessarily always black and white, but once a decision is made, it's a decision made in law. And to overturn that decision in law requires specific criteria. Because when we set up the law, we said it can be overturned on the basis of this, this, and this. If you can't prove those, then the appeal court won't take the case. I mean, I think she's already appealed twice and it's been turned down, I think. It's got to go to the Criminal Case Review Commission to be looked at if it's going to be. But it's all about, are the criteria met? And if they aren't met, then there is no reason for the case to be reopened. So there is a rigidity in there that is there to create strong boundaries, but that doesn't mean that they're the right boundaries.
Because one of the criteria is, has new evidence emerged since the case? Now, that's not true in the Lucy Letby case. So simply to come back and say she had a terrible defense, which seems to be, I mean, and by terrible, I mean hopeless, incompetent, doesn't cut it.
That's not a reason.
And you can't say the expert witnesses were not interrogated properly. I mean, presumably, if it could be shown that the expert witnesses had perjured themselves or something like that, but that's not going to happen. So it feels, I'm sure I'm not alone in this, in feeling there's something frighteningly frustrating about the way that the criteria are set up for a case like this. And I know this isn't the only case, and as you say, the pain is spread widely in this case, and one shouldn't only focus on the person who was convicted. But it feels tough that the Court of Appeal has rejected this one twice.
There isn't an easy answer to it, as I've said, but there does have to be strict guidelines that say, if you have this, this can happen. If you don't have this, this can't happen. Otherwise, what you get is such a grey area. And within there, there's room for exploitation. So unless the court is prepared to back down, which I don't believe it will, then we are where we are. And there's a possibility that you have an innocent person serving life in prison, but there's also a possibility that you have the guilty person who is where they should be, serving their life in prison. The people who are the triers of fact are the jury, and the jury made the decision. Theirs is the ultimate decision. But my fear is that they made it on evidence that was not balanced, that gave them the opportunity to see all sides. That's not one of the criteria, I'm afraid, for review.
The other thing that can happen is that the system recognizes it has made a mistake. And you write at the end of your book about a really harrowing personal experience that you had. And it feels like there are two extremes here. This very, very resistant system doesn't want to acknowledge, wants to set the barriers very high. But then occasionally it says, yes, we did get this wrong, at which point it trashes the reputations of everybody involved. It's almost as if it has to say, when we do admit that a mistake was made, everybody involved in this is somehow complicit in this mistake. So if you're okay talking about it, you wrote about it, so I feel like I'm allowed to ask you about
Of
it.
course
So
you
you
are.
say how hard it is to talk about. Do you want to just talk about that experience that you had?
I mean, it was a really sad case because it was the death of a child. And the Crown case, for whatever reason, and we don't understand it, decided that what they would do is they would charge the mother with murder, not with manslaughter, not with neglect, but just with murder. And we were brought in as forensic anthropologists because our job was to determine how old was the child when they died, because there was a question about when the social workers had last seen the child alive. And we're able to look at both the bones and the teeth to be able to determine the age of the child. And the younger the child, the more reliable we can be. So our role in the case was not controversial in any way. And we know that when we look at the teeth, we get a closer age estimation to the chronological age of the child than if we look at bones. Because if a child is malnourished, what the body does is it sort of puts body growth into hold. But for some reason, the teeth are spared. So teeth are always closer to the real age of the child than bones are. And we were able to show that disparity between the bone age and the dental age and to say the dental age is most likely. But for some reason, the defense team, and we've no idea why, wanted to focus on the fact that the bone age of the child, we had identified there are things called Harris lines. And Harris lines are lines of increased density that occur at the growth plate of the bone. And when your body goes into a starvation mode during growing, what happens is that the bone goes into a stutter. And you don't get nice normal bone growth, you get these dense lines. Now, we don't know what's caused them. All we know is the body is responding to a stress. And that is all we were saying in this case. It was the most aggressive cross-examination I've ever had, and the clear determination was to prove that we were incompetent. And I couldn't see where it was coming from because we were in an area well within our area of expertise, and we were not overstepping the mark. So, you sometimes think, I don't know why this is happening, but it's happening and I don't like it. And I got off the stand, and my junior colleague took the stand after me, and he just got led down such a blind alleyway that he never worked as a forensic expert again because he found it all so utterly distressing. At the end of the case, the jury found Mum guilty, and they found her guilty of murder. And I don't believe she did murder her child. I think she neglected her child. And so there was an appeal, and quite rightly, there was an appeal, absolutely full support of that. But the appeal court judge, for whatever reason, I mean, he upheld the appeal, which I think was the right thing to do. But for some reason, he just decided to take a Gatling gun and just spray everybody within sight. And, we were accused of being quacks. The judge got it in the neck. The prosecution got it in the neck. Absolutely everybody in the case got it in the neck, which really wasn't justified as far as we could see, anyhow. And then I thought, well, I'm really concerned about this because there is a floodgate possibility here. If I am proved to be an expert who is deficient, then there's a possibility of every case that I've ever done being brought back under the microscope. And from somewhere deep inside me, I felt the need to fight. Maybe it's the Scottish redhead in me, I don't know. But I felt it was wrong because we were being accused of things that we were not, I was absolutely adamant and certain we were not guilty of. And so one of my colleagues previously had been our head of communications in the university, and she was now an MSP. And I phoned her up and I said, look, I need to do something with this. What do I do with it? She said, you need to get it in front of question time with the First Minister, who at the time was Alex Salmond. I said, how do I get a question in front of Alex Salmond? And she said, well, I have to put the question forward. So she wrote the question, which was something along the lines of saying, you will have seen the outcome of this case. You will have seen the disrespectful language used against the experts and other people within the courtroom. What does this say about our justice system? And that happened. Our question was accepted on the Monday. And I knew I had till the Thursday before Alex Salmond would stand up in Holyrood. It was a very, very long 4 days, I have to tell you. What I believe happened was that the Lord Advocate, because of course it would land on his desk, because he's the advisor to the Scottish Government, the question would have landed on his desk to say, this is within your field, this is the legal field. What's the answer here? And he would have then gone and spoken to the Lord President, and the Lord President had a look at it and said, yeah, this is unacceptable. This is not the right way for our legal system to behave. And it is not right and proper for experts to be handled in this way. So directly before, only I think, a matter of hours before Alex Salmond stood up in Holyrood, there was an apology issued by the Lord President for the way in which we had been addressed and the way in which we had been dealt with so harshly by the appeal court judge. So Alec could stand up and say, you will have seen we have issued an apology. Now, I don't believe that the judicial authorities in Scotland have ever issued a press apology before. And it went a long way towards making me feel that we had been right. We hadn't done anything wrong. Whatever it was that that judge had decided he wanted to punish us for, we didn't know what it was. And then I found myself in the Parliament buildings one day, and a message came through from the Lord President to say if I had a moment, he'd like to speak to me. And he came into the room, and you don't know whether to stand or bow or whatever. This is the most senior law lord in the land. And he wanted to issue to me both his personal apology and his professional apology for the way in which we were treated. And I don't think I had realized up until that point just how traumatized I was by that case. Because when I went out into Parliament Square, my colleague turned to me and said, well, that was a bit of an unexpected turnaround. And I literally broke. I think I must have howled with tears. And it's not something I do. I'm a very contained and controlled person. But it told me just how much that case had built up within me. And I, at that point, thought, I'm not going to do this again. Why would I put myself through this again? And then I gave myself a serious talking to and said, if that happens every time, we will have no expert witnesses left. Pull your big girl pants up, get on and get back into the courtroom, girl, because you stood your ground and the law lords of Scotland recognised that you had been treated unfairly. I don't know where I got the sheer bravado to do that. I really do. I don't think I would do it now. Maybe it was youth, but it was close to being the last case that I ever did. It was so traumatic.
And it really highlights the precariousness of the role of expert witnesses because, as you say, had the criticism been allowed to stand, not only could you never have been an expert witness again because it would have been too easy to just simply quote,
Oh, every single defense lawyer would bring it out. Yes.
but also the damage is retroactive as well in the sense that it just takes, and it's not, in this case, it's absolutely clearly not your misstep. And in the case, what's so baffling is that the misstep seems obviously to be the prosecution's decision to charge the mother with murder.
And the appeal, therefore, was right. Absolutely in support of it.
Yeah. And it's not the jury's mistake because the jury wanted to convict and they were only given one option, but for the damage to be sprayed so far and wide. But it is only one mistake, whether it's the expert witness or it's made by someone else, and it destroys that person's reputation. And it's all over. It's all over.
Yes. So as a scientist, going into the courtroom, all you have is your reputation. And one side wants to build it and the other side wants to destroy it. And it only takes that destruction to be successful. And that's it. Your career is over. Nobody would ever look at me as a credible forensic scientist again. I wouldn't get the casework. Would I publish research? Possibly. Would I get a grant? Probably not. So, your life shuts down. It did the same with Roy Meadow. Different reasons. But technically, he was struck off. One could argue maybe it was the right decision. Who would know? But that's what can happen to an expert witness. Every time you go into a courtroom, you think, will I come out alive on this as an expert? And when I got to my final court case, which was in Chelmsford, and nobody knew just how critical that case was to me because it was my final one in the courtroom. And I thought, I've survived all these years. Is this going to be the one that brings me down? So I was nervous as a long-tailed cat in a factory of rocking chairs. I really, felt sick. I couldn't eat in the morning. And it was the most straightforward case I have ever done in my life because the defense and the prosecution came together. They questioned me together. They decided on their strategy. I knew what it was. I knew what they were going to cross examine me on. And it just went like a dream. We all did our job. And that showed me that it can be done. And that's what gives me hope for our justice system. That when the Crown and the defense and the judge and the expert witnesses are working together, then that's the best possible outcome we can have.
I want to ask you a couple of last questions about where this may be going. I think a lot of people probably associate what can go wrong with the expert witness system in an adversarial criminal justice system with the United States. Some of it is just anecdotal or things that people have seen on TV, but the idea that there are expert witnesses for hire, there are professional expert witnesses who will make themselves available to the people who will pay them the most, and that the line between good science, pseudoscience, and bad science is not particularly clearly demarcated. I'm sure this is not true across the board in the United States, but there are parts of that system where it almost certainly is true. Is any of that becoming more true here?
No, I don't think so. Certainly in the criminal courts, you are not an expert witness for hire. So that you literally will get paid what your time and your expenses are. You're never going to get rich as an expert witness in a criminal court, and you never should. There is a very big price tag on being an expert witness in places like the States. There isn't here. It's not true from the civil courts. So in civil courts, then there can be a very reasonable living to be made as an expert witness in the civil courts, but not in the criminal courts, no.
And the line between science and pseudoscience, is it holding in this country?
I think there's been a bit of a reawakening for the science. There's really good science out there, really solid, good science out there. There's a group of sciences in inverted commas that perhaps have got the potential to be really good sciences, but we need to invest in them. We need to do the research in them. We need to have the funding. And so sometimes we have to retrofit the science to the situation. And DNA was a classic situation of that. When Alec Jeffreys identified that he thought his DNA experiment had gone wrong, and what he'd really found was that everybody's DNA was different. I mean, there's a game changer moment for you. But Alec was very, very upfront by saying he was able to exclude somebody from being the suspect. If he'd had to go into court and give a probability or a likelihood for the individual being the suspect and the offender the same person, then he couldn't have done it because he didn't have the statistics. That had to be retrofitted, and it has been. So sometimes science is ahead of itself, and we have to know where its boundary is, retrofit it, and we can bring it forward. And there are other sciences that aren't sciences. Pattern matching isn't a science. There is statistics behind it, but we need stronger statistics behind it. And pattern matching, we saw with fingerprints, for example, in the Scottish fingerprint inquiry, just how wrong even fingerprints could go with the Shirley McKee case.
And the other thing I wanted to ask about was whether this is a level playing field. As you write, it's much easier for the Crown to access expert witnesses than it is for the defence. Not simply because the Crown might be better resourced, but the Crown has a natural relationship with the institutions where expert witnesses might work. Many of them will be funded by the state. Let's not call it the Crown, let's call it the state, because this is the state that we're talking about. So those lines of connection, those networks are much more real on one side. And on the other side, many defendants are very poorly resourced. They may be poorly served, to go back to the Lucy Letby case, by the person who is their representative in court. Is it a level playing field? And is it going to get worse? And one of the things I'm thinking about here is the technology is moving so fast, we don't know where AI is going to take this. But there must be a risk that you can either be very well resourced in this area, or you can be more or less cut off from the kind of resourcing you need to be able to bring expertise to bear on the case from your side. Do you think there is a danger that this is going to become more unbalanced?
So there is no equality of arms. There simply isn't. So if you look at the levels of legal aid, for example, my daughter was a trainee criminal defense lawyer and she saw it literally up front. She'd say, "Mum, I'd get the case on Monday morning, and 10 minutes later, I was in the courtroom presenting it because it was whichever duty solicitor was available. That's who you got, however experienced or inexperienced they may be. The workload is horrendous. There is no funding." In legal aid, very little funding. There is no funding to allow extra testing to be done. There's no funding to bring in experts. If you want to bring an expert in, then legal aid has to agree to the cost of those experts. And many experts are very content to appear for the prosecution. They are less content to appear for the defense. And I have a real problem with that because we're meant to be impartial. And it shouldn't make any difference whether we're retained by one side or the other. Our evidence should be exactly the same. But you're innocent until you're proven guilty. And that proof of guilt, beyond reasonable doubt, is very much stacked towards the Crown and the state, who've got the investigative forces, because that's what the police are, who have the Crown Prosecution Service or Procurator Fiscal Service, or whichever it is in different countries around the UK, and it's their courtrooms. So that everything is stacked very, very heavily towards the Crown and the prosecution side. And the defence side is very much the poor partner. And for them to be in a position to be able to get a case to the criminal court's appeal process is a Herculean task because there is no equality. We should have experts who are literally in a pool of experts that can be pulled equally from one side or the other. And it shouldn't be funding that dictates which side you come on. Justice requires impartiality. It requires a jury to listen to evidence, to listen to strong evidence, to be guided, and then to make a decision. But if, as we've heard in the Letby case, it's so skewed to one side or the other, then that's not serving justice. Is it going to get any better? Probably not, because we're not going to pour money into the defense system. And what we're seeing, in fact, are independent forensic practitioners are being pulled back either into commercial companies whose procurement is to the police, not necessarily to the defense. And we're seeing scientists being brought back into police forces. So we're seeing science being drawn to that side of the pendulum in a very, very uneven way compared to defense. There is no institute that a defense lawyer can go to. They will find someone who's prepared to look at a report, perhaps from the prosecution, but they might not ever be called to court.
The boosters of AI would say AI is going to level this playing field because AI will be your expert for you. AI will be the thing that will be available to anyone who wants to access it. For people who are listening, I can say I'm getting a skeptical look on the screen. It's not going to work like that, is it?
Well, I mean, AI is only as good as the information and the data that it trolls.
And AI is a pattern recognition system. We have to recognize that. So it's a pseudoscience. Let's call it for what it is.
With AI, what's really interesting, the conversations that I'm starting to hear about AI, is that some amazing opportunities and things that it can do. It probably will have a role in the courtroom. I have no doubting that. But what we're also seeing is a real sort of discomfort at the separation of what is the artificial intelligence from what is the actual intelligence, the other AI, which is the actual intelligence. And that actual intelligence requires humanity. It requires philosophy. It requires thinking. It requires judgment. It's not about taking artificial intelligence and using just simply what's there and recycling it. The real intelligence is about being able to create new information that challenges what we know. And that humanity is what we need to hold on to. We need the investment in our arts and our culture, in our philosophers, in those individuals who think for a living, because AI is not thinking for a living. It's regurgitating whatever we put into it.
Sue Black's book about this subject and about her extraordinary experiences in courtrooms is called An Expert Witness, Forensic Science on Trial. It's also a really interesting history. A reminder that the final episode in our series on the history of bad ideas is available now on PPF+. It's a conversation with the geneticist and science writer Adam Rutherford about what's wrong with the idea of genealogy, our hunger for genealogy. Why are we so desperate to know where we come from, biologically, genetically, familiarly? And what are the things that can go wrong when we think we've found that out? Here's a clip.
There's a concept within population genetics, which is the field that I study, which is called coalescence theory. And it's the notion that your family trees, everyone in history has had two parents, right? Obviously, and that has to be true, which means that the number of ancestors you have through the generations doubles every time. Now, very quickly, that number becomes absolutely unsustainable because you have more people in your family tree than have ever existed on Earth. And that occurs only after about 40 generations, which is about 1,000 years ago. Right? So all of a sudden, you've got this problem, which is that you, David Runciman, your family tree has more than 1 trillion people on it 1,000 years ago, and yet we know that only about 100 billion people have ever existed. So what's the answer to this conundrum? The answer is that your family tree does not double the number of people in it, it doubles the number of positions. And as you go back through time, it begins to straighten out and it begins to cross over. And eventually you get to this point in history, which is we call the genetic isopoint. The isopoint is defined as the time in history where if you were alive then and you have any living descendants today, then you are the ancestor of everyone alive today. And for Europe, that number works out at about 1,000 years ago. So if you can show anyone has living descendants today who was alive 1,000 years ago, then that person is the ancestor of everyone living today in Europe.
If you'd like to get that episode and all of our bonus episodes, past, present and future, there are 2 new bonuses every month, plus ad-free listening, plus automatic sign-up to our newsletter. It costs £5 a month or £50 for the year. It is also invaluable support for this podcast. Just go to the link on our show description or go to our website, ppfideas.com. And if you go to the PPF Plus page, you will see all of the bonus episodes waiting for you as soon as you sign up. Next time, we're starting a brand new series, and it's something a bit different from what we've been doing recently. It's about the lives of 20th century philosophers. I'm going to be talking to a series of contemporary philosophers and writers about some of the great philosophical thinkers of the last 100 years. From A.J. Ayer to Iris Murdoch, from Simone Weil to Jean-Paul Sartre. And we're going to be exploring the life through the thought and the thought through the life. How does biography illuminate philosophy? How can philosophy explain a biography? We're starting with a conversation with the writer and philosopher Nikhil Krishnan about the life and thought of A.J. Ayer. That's next time. This has been Past, Present, Future.